Well, I'm not sure whether to say good evening or good afternoon. It's good evening in my part of the world. Good afternoon to most of you. My name's Susan Kneebone, and I'm a professorial fellow at the Melbourne Law School, also a research affiliate of the Peter McMullen Centre on Statelessness. I welcome you to this Refugee Law Initiative panel, session 3A, the title of which is More Than Its Constituent Parts, How to Understand the Refugee Convention. And this is a session in which we're going to look at some of the less commonly discussed legal aspects of the treaty regime, asking whether the Refugee Convention indeed adds up to something more than its constituent parts. The first speaker tonight is Dr. Kathryn Lucy Allinson of the University of Bristol, and she will be talking about protection, not prevention, exploring the absence of a prohibition of displacement within the 1951 Refugee Convention. Just before I welcome Kathryn, I have got a few little house rules that I need to remind you of. Each of these speakers will have 10 minutes and we'll be strictly enforcing that. We ask you to pose your questions and comments to the speakers by typing them into the chat box on Zoom. After the speakers have finished their presentations, there'll be time for them to discuss and reflect on your questions and comments. Please remember to keep your microphones on mute and your video off unless you're a presenter, obviously. The session is being recorded and will be posted on the Refugee Law Initiative website as a podcast. If you don't wish to appear in the podcast, we ask you to leave the session now. If you wish to hide the live transcript at the bottom of the screen, please click the hide subtitles button. So we turn first now to our speaker, Kathryn Allinson, who, as I mentioned, is talking about the absence of a prohibition on displacement. Thank you, Kathryn. You have 10 minutes.
Thank you very much. Hopefully everyone can hear me and see the PowerPoint. So this panel is seeking to understand the Refugee Convention, and I'm going to begin by examining something we all already know, that the Refugee Convention focuses on to whom and how international protection should be provided. But I want to interrogate why this is the case and why the Refugee Convention does not contain a prohibition on the causing of refugees. So to answer these questions, I'm going to make 3 points. Firstly, given the historical context in which the convention was drafted, it could only ever have been focused on protection of a very specific group of people. Secondly, doctrinal analysis of the convention and its object and purpose demonstrates that whilst in its implementation, it is necessary to make an implicit judgment of the country of origin, this is only to establish to whom protection is owed for the purposes but not for purposes of accountability. And thirdly, given this specific focus on protection, it's not for refugee law to prohibit or prevent displacement, because to do so would risk muddying the political waters and weaken protection. Instead, we must look to the wider system of international law. So there are 2 points I want to make on the historical context. The first is the effect of the growth of the nation state and the rise of nationalism and the end of empires in the late 19th and early 20th century, which resulted in a drive of the modern state to categorize and homogenize its populations. Nationality became the means by which to access the protection of one's own and other states. So this is evident in the development of passports, which enabled individuals to legitimately move with proof of their nationality. And whilst passports have a long history, it wasn't until the First World War that European governments introduced passport requirements at borders to control the movement of people. Further, there was an ongoing debate throughout this period regarding the rights of aliens. A person outside of their state of nationality was only protected if they enjoyed diplomatic protection. And the concept of equal rights was only really just emerging. And whilst the rights of minorities were protected under some ad hoc agreements, for example, those made during the Paris peace settlements, aliens often fell outside of this purview. So there was little understanding of rights for non-citizens. And secondly, is the effect of this growth of the nation state and push for homogeneity had on the legitimacy of forcible transfer. So in the first half of the 20th century, whilst there was a recognition that the unilateral kind of flooding of another state with population flows was contrary to public international law, there were a number of multilateral agreements that essentially permitted the ethnic cleansing of large areas. So a couple of examples: the Treaty of Lausanne, which was in 1923, permitted the forced population transfer between Greeks in Anatolia and Turks in Greece along the religious lines. And the Potsdam Agreement in 1945 permitted mass expulsions across various parts of Europe. And the creation of ethnically homogeneous nation states was presented as the justification for this and gave rise to the series of expulsions and resettlements of Germans, Poles, Ukrainians, and others. So what this tells us is that come the end of the Second World War, the forcible transfer of people had been and still was something that states viewed as within their sovereign powers to legitimately do. But on the other hand, throughout the same period, we saw people fleeing their state of nationality, seeking protection from persecution. This uncontrolled movement presented a problem in the world of increasingly controlled borders. And in this context, Nansen passports built upon a long-standing institution of asylum, an institute which was recognized by states throughout the interwar and post-World War years as protecting a fundamental right to seek asylum. And these passports ensured that those without travel documents and moving without protection of their nation state could do so to access protection elsewhere. These were then formalized for specific groups in the conventions relating to international status of refugees. Their purpose was to put in place a process whereby refugees could access rights and protection. So what I think is really interesting about this context is you've got two contrasting things developing. On the one hand, a situation where movement and protection is being increasingly controlled on ethnic lines, and forcible transfer of individuals to somewhere deemed to be their state of nationality, though they may never have lived there and are forcibly transferred there, is permitted to ensure national homogeneity. Whilst on the other hand, there's an acknowledgement that persons forced to flee persecution for a convention reason is in need of an international protection. So in one context, forced displacement is a necessity. In the other, it places people in need of international protection. And at this time, these were seen as very different situations. And so as a result, the idea that forced displacement was per se a wrong, I don't think existed. And so the 1951 Convention, developing to pass judgment on the source of persecution or the need for protection, just could not have happened. Instead, it focused on the very specific group of people that were deemed in need of protection because of a lack of protection from their state of nationality. And this brings me to my second key point regarding explicitly the Refugee Convention. What can this tell us about the role of protection or prevention of refugee flows? So in considering this, I'm going to focus on the implications of finding that an individual, due to a well-founded fear of persecution, is unable or unwilling to avail themselves of that protection. So firstly, the establishment of a well-founded fear does require a subjective assessment of the individual's fear of persecution, but this must also be well-founded, such that it requires an objective assessment of conditions in the country of origin. Then persecution requires an assessment that there is a threat of a sufficiently severe human rights violation. And there must be some connection between that persecution and the failure or conduct of the state. As such, when a person is found to be fleeing persecution for a convention reason, there must be a judgment of fact made in regard to this failure on the part of the state or abuse by the state as the perpetrator of violence. So ascertaining that an individual is a refugee in need of protection does include a factual assessment of the country of origin, but its purpose is concerned with when and how protection can be provided. So the Refugee Convention, the 67 Optional Protocol, and UNHCR and its guidelines, none of these instruments or organisations were intended to pass any legal judgment on the source of refugee flows. They're focused on the fundamental questions of who to protect and how to protect. So as a result, I would argue that the 1951 Convention and refugee law more generally should not and could not have developed to prohibit the causing of refugees, because linking the provision of protection with the judgment of the country of origin would have huge implications for that protection. Take the 1967 Declaration of Territorial Asylum, which states that to provide asylum is a peaceful act that cannot be regarded as unfriendly by any other state. This is because if the provision of asylum or refugee protection was in any way linked to a judgment of the country of origin or could be viewed as an aggressive act would result in countries thinking very carefully about whether they would provide such protection for fear of the political or military repercussions. Thus, when we look at the purpose of the Refugee Convention and to whom it applies, it's evident that it's developed to facilitate very specific protection of individuals who feared persecution for a convention reason. And to distill this would be to undermine its ability to fulfill this purpose. And so very briefly on my final point, if it's not the place of refugee law to pass judgment on the country of origin, what are other avenues to ensure accountability for displacement? What we can see is that international law is developed to fill this gap and to start to provide accountability mechanisms for victims of displacement. So in the specific context of armed conflict, Article 49(1) of the Fourth Geneva Convention prohibits deportation and forcible transfer. And further, at the time the 1951 Convention was being drafted, the Nuremberg trials were utilising public international law to hold individuals accountable for the genocide and huge displacement that occurred during the Second World War. And this is the foundation for the International Criminal Tribunals and the ICC, which have continued to hold individuals to account for forcible transfer and deportations under Articles 7 and 8 of the Rome Statute. But furthermore, it's international human rights law that's developed so dramatically over the last 70 years. And it's here that we're seeing the question of the human rights of people not to be displaced developing. And a number of academics have written about the right not to be displaced and deriving this from existing human rights. And this is increasingly evident in regional human rights conventions, as well as the guiding principles on arbitrary displacement, internal displacement, sorry. It's not the purpose of this presentation to go into details of this, but my final point is just to note this shift from the the Treaty of Lausanne and the Potsdam agreements, where forcible transfer was permitted, to the early 21st century, where we are now seeing displacement as a wrong in and of itself. But these developments have happened outside, I would say, but in conversation with refugee law. And so to very quickly conclude, in the early mid-20th century, the act of forcibly displacing large groups of people was not viewed as an inherently wrongful act, but was one that in certain situations was deemed necessary. And so as a result, the 1951 Convention developed to address the flows of people seeking protection from persecution without passing judgment on the source of that persecution or the country of origin's failure to protect them. Displacement and the fleeing of persecution is taken as a given. And so in order to understand the other avenues of international law, we must look to the broader prohibition of displacement within other branches of the law. Thank you very much. I will stop there.
Thank you so much, Kathryn. That was really, really interesting. The history is so important in trying to understand the gaps in the Refugee Convention. I'll turn now to, and thank you also for keeping on time. I'll turn now to our second presenter, Dr. Kate Ogg from ANU, Australian National University, Canberra, Australia, who is talking about Article 1D of the Refugee Convention, obviously, getting wiser with age, Article 1D jurisprudence from stuck in the past to pointing to the way forward. So good luck, Kate. Thanks,
Susan. Thank you. So the research I'm presenting today comes out of my forthcoming monograph, and I only discuss Article 1D jurisprudence in one chapter in the book, but the reason I'm presenting it today is because it fits just so beautifully with the conference's theme, Aging Gracefully, ? So there's a really rich tradition of engaging with refugee law jurisprudence, that I'm sure you all know from feminist, twale, critical race, post-colonial perspectives. But these theories haven't been applied to Article 1D jurisprudence, which is, you know, on the face of it, Article 1D would have such an interesting story to tell, especially with respect to race and colonialism. So most of the scholarship, the legal scholarship on Article 1D has a doctrinal focus. And that's been incredibly important because in the words of the Federal Court of Australia, Article 1D is pregnant with ambiguity. So the most of the legal scholarship on Article 1D really focuses on the first paragraph of Article 1D. Unfortunately, they're not numbered in the Convention. So the first paragraph, which is really the exclusion paragraph, excluding Palestinian refugees from the Convention. And there's a debate about whether this is historically bounded, whether it only applies to Palestinian refugees displaced in 1951, or whether it has continuative effects, so whether it applies also to their descendants, Palestinians displaced because of subsequent hostilities, and their descendants as well. So that's where most of the debate is. I instead focus on an issue that's received a lot less attention, and that is the second paragraph. So I've highlighted there in red for you. We might call that the contingent inclusion paragraph. So let's say, and I am agnostic about this, let's say that Article 1D does have continuative effect, and that is the position that the overwhelming majority of states take. It has continuing effect. When does that contingent inclusion paragraph, the second paragraph of Article 1D, when does that apply? How is it triggered? What are judges doing with this second paragraph? That's the question that hasn't got a lot of scholarship on it, and that's the question that I look at in my research. And I argue for that, for the most part, this jurisprudence on Article 1D, on its second paragraph, reproduces the patriarchal, racialized and neo-colonial approaches to refugee law judging observed by first wave scholars in the 1990s. So is the Refugee Convention aging gracefully from the perspective of Article 1D jurisprudence? Most probably not. It's very much stuck in the past. But, and this is important, there's some very recent decisions, some 2019, 2020 decisions that are indicating a shift towards not only a more protection sensitive approach for Palestinian refugees, but also one responsive to concerns of contemporary post-colonial refugee law scholarship. And I'm thinking of Achiyumi scholarship in particular. So it really has lessons not only for those of us interested in Article 1D or Palestinian refugees, but for the future directions of refugee law jurisprudence and legal scholarship more broadly. So going to the case law, one of the most important cases on the second paragraph, Article 1D, is the decision I'll just refer to it as Elcott by the Court of Justice of the European Union. Now, unfortunately, the court didn't define this term. I'll go back to the clause for you, protection and assistance in Article 1D, second paragraph. Neither do the UNHCR guidelines on Article 1D. Instead, what the court went directly to is ceased for any reason. And the court outlined these three factors as to when it can be deemed that protection and assistance has ceased for a Palestinian refugee. My view is that third factor, a Palestinian refugee must leave an UNRWA area of operation, for reasons beyond their control. That is the factor that's had the most influence on subsequent jurisprudence. And the court said that a departure will be deemed involuntary when UNRWA cannot guarantee living conditions and so it's a cumulative test, the Palestinians, refugees' personal safety is threatened. We get another significant decision on Article 1D's second paragraph in the New Zealand decision AD Palestine. Now, in this case, the New Zealand Immigration and Protection Tribunal did interpret that phrase protection and assistance. And I think it did a really rigorous job of interpreting UNRWA's mandate, looking at scholarship about UNRWA's mandate, looking at international instruments and how they set up a regime of protection and assistance that Palestinian refugees have a right to. So it's a very significant judgment from that perspective. My view of the judgment is that the downfall of it is that it refers back to Elcott. So through a process of transjudicial communication brings this test of forced migration into Aotearoa, New Zealand, Article 1D jurisprudence. And it says that Article 1D second paragraph won't be triggered unless there's some degree of compulsion in that process of leaving, so forced or involuntary migration. So my view is that this test of forced migration, I think these decisions bring it into the 1951 Refugee Convention for the first time, and it sets up an evidentiary paradox for Palestinian refugees, because that second paragraph of the Article 1D can only be triggered by, leaving, for example, Jordan or Gaza or Lebanon, an act that is inherently an act of agency, a very difficult feat for most Palestinian refugees, many of whom are stateless, And yet to obtain the benefits of the Refugee Convention, they then have to prove that the departure was actually involuntary. And adding to this, looking at this lens through the lens of critical, through looking at Article 1D through critical scholarship, I mostly look at Tuoht, Chimney's and Achiumi's scholarship. The stories that decision makers favour when determining whether flight was involuntary really echo Chimney and Tuoht's 1990s scholarship, their observation on Western states' reactions to the new, so-called new asylum seekers. So Chimney and Tuoht explained that when larger numbers of refugees from lower income countries started to arrive in the global north, they were perceived as economic migrants and were distinguished from the authentic refugee fleeing political strife. So neither the CJEU or the New Zealand Tribunal are satisfied that poverty, poor access to healthcare, lack of education, employment prospects are enough to prompt a Palestinian refugee to flee against their will. Rather, forced departure is predicated by something more than dire humanitarian circumstances. So the CJEU focus on threats to personal safety. The New Zealand Tribunal emphasised discriminatory denial of human rights. So the New Zealand Tribunal was about a group of Palestinian men from Gaza, and the tribunal did highlight unemployment, poverty, lack of infrastructure, civil unrest in Gaza, and UNRWA's difficult financial circumstances, but said that the only reason that the inclusionary paragraph in Article 1D, the second paragraph, was triggered was because these men were Christian. They would have faced discrimination in employment because of their religion. They would have also faced risks to physical security when publicly practicing their religion. So it was the cumulative effects of those matters that satisfied the tribunal that this was forced migration. They left not according to their own will. So the tribunal's approach has parallels with Tuoht's critique, Patricia Tuoht's critique of the definition in the 1951 Convention, the definition having a Western ideological slant due to its insistence on establishing fault. So by requiring evidence of something beyond the general living conditions in Gaza and looking to religious discrimination, the tribunal imported the idea of culpability into Article 1D's second paragraph, but without any textual basis for doing so. And the final point I want to make, drawing on Achiumi's idea of xenophobic anxiety, I argue that this creation of the forced migration test in Article 1D is not only a way of limiting Article 1D's contingent inclusion paragraph, it's also an assertion of sovereignty. So global North states are choosing which refugees they want to welcome, which Palestinian refugees, and accepting only those whose journeys were involuntary. European and Aotearoa New Zealand decision makers are positioning their nations as saviours of those few who had no choice in leaving, but protecting their borders from the thousands who supposedly did have a choice. Now, from a feminist perspective, when determining what types of harms trigger involuntary flight, decision makers often favour harms that emanate in the public sphere. So in that first Belgium decision there, the 2015 one, the decision makers accepted that a Palestinian man from Gaza who was a photojournalist who said he was shot at by Hamas, shot at by the Israeli army in his everyday working life. Of course, he had no choice but to leave. This was, he had no decision, he had to leave. But the same decision was not reached with respect to a Palestinian woman subject to forced marriage. But, and so this is the final point I'll make, I know I'm coming to my 10 minutes, there has been a handful of decisions, and here's a few on the slide for you, 2019 and 2020, that have just accepted that UNRWA's financial circumstances basically means that Palestinians do not have protection and assistance. So that is all Palestinian refugees trying to trigger Article 1D's inclusion clause and get ipso facto the benefits of the Refugee Convention almost don't have to prove anything. They, just have to refer to UNRWA's difficult financial circumstances. So this is of course significant in the Article 1D context. It signals perhaps a shift, but beyond this, I think it's significant because it's examples of refugee law judges acknowledging, responding meaningfully to the lack of international cooperation in the global refugee regime. I'm only aware of one other context and where I've seen this type of reasoning that is, while not directly citing, in line with international cooperation. I'm finished, Susan.
Thank you, Kate. That was fascinating, very fascinating. We'll move on now to our next presenter, Professor Hélène Lambert from the UTS Sydney, University of Technology Sydney, the temporal scope of refugee protection from armed conflict in Australia and the United Kingdom. So over to you, Hélène. Thank you.
Thank you, Susan. So in my short presentation today, I interrogate what do we know about the precise role of time in the assessment of refugee protection claims. UNHCR guidelines number 12 on armed conflict of 2016 acknowledge that time is a relevant factor in the application of the well-founded fear test. But otherwise, there is very little scholarly work on the temporal scope of the refugee definition, namely on how considerations of time interact with states' assessment of probability and risk. So my co-authors, Jane McAdam, Michelle Foster, and Hannah Gordon, and I, we investigate this question in the case law of Australia and the United Kingdom, relating specifically to claims for refugee protection from people fleeing armed conflict. And so my remarks today are cursory at best, and they are based around 3 points. My first point is that the senior courts and appeal tribunals of Australia and the UK have long engaged with considerations of time when assessing protection claims. So there is ample jurisprudence on this issue. A most notable example is the well-known case of Sivakumaran from 1991, where the House of Lords clearly stated that whilst fear of being persecuted must be current, the harm to which it relates may occur now or in the future. And it explicitly rejected restricting the time frame of analysis to the immediate future. My second point is that when assessing whether a person has a well-founded fear of being persecuted, the time frame is that of the reasonably foreseeable future. Now, what this precisely means for the courts is unclear. The time frame seems to be somewhere between the not too remote and the present or immediate future. However, what is clear from the case law, and indeed crucial, is that the senior courts of Australia and the UK consider this time frame to contain a degree of speculation. And here a decision of the Australian High Court in Wu Shang Liang is particularly useful for noting that speculation can mean two things. First, it can mean prediction in the future, in the temporal sense of foreseeability. Second, it can refer to the probative force of the material before the decision maker, in the sense of certainty of risk. Now, the High Court of Australia recognized that the first meaning was the critical one, namely the assessment of real chance of harm involves speculation in the sense of prediction. To be sure, foreseeability and certainty of risk are not to be conflated. Yet at times, not often, but still, and perhaps more so in the UK than in Australia, we found decisions where conflation between the two has occurred. And that was particularly the case where the situation, cases where the situation in the country of origin is relatively stable at the time of decision, but nevertheless fluid. And this brings me on to my third and final point. How have appeal tribunals in Australia and the UK engaged with risk speculation in the foreseeable future? And here we noted that the tribunals have from time to time sidestepped the core question of whether a risk is foreseeable to focus instead on speculation about how a risk can be mitigated or avoided. And we argue that such an approach is distracting and mistaken in that it leads in effect to applying a higher standard of proof than the required standard of proof in refugee cases. We further noted that appeal tribunals have also on occasion conflated foreseeability and certainty of risk, particularly in cases of relative stability or peace. And they did that by requiring that risk be imminent, immediate, present, or current at the time of decision, thereby overlooking the situation's potential volatility. Heavy reliance on country of origin information, which inherently deals with the past and present, accounts for much of this approach. So to conclude briefly, decision makers have long engaged with concepts of time in the refugee definition, but not in a systematic way. So bringing temporal considerations into refugee law enables us to critically interrogate judicial processes of inclusion and exclusion. Considering that armed conflict continues to be the main driver for people claiming refugee protection in Australia and the UK, how courts and tribunals understand and apply the time frame of reasonably foreseeable future, particularly in situations between peace and conflict, is key. Our research highlights some best practices in that regard, including ensuring that this time frame does not expand and contract with the apparent certainty or uncertainty of a situation. Thank you, and back to you, Susan.
Thank you, Hélène. I'm coming. Sorry, you took me by surprise. Thank you very much. That was fascinating. I have read some of this research in other forms, and it is very important and very fascinating. Thank you. So we can turn now to our final speaker, who probably needs no introduction, Professor David Cantor from the Refugee Law Initiative, who will talk about non-discrimination as the rationale of the Refugee Convention. And can I remind everybody, please, to continue putting your questions into chat. We've got some fascinating ones, and we can have a nice, healthy discussion when we have finished David's presentation. Thank you, David.
Great. Many thanks, Susan. Discrimination is one of those things that's at the heart of refugee experiences. Yet, curiously, the concept of discrimination itself appears only intermittently in efforts to interpret refugee law. The 70th anniversary of the 1951 Refugee Convention, then, presents an ideal opportunity to address this omission. Accordingly, the paper I'd like to present today shows how the concept of discrimination is, in fact, intrinsic to the Refugee Convention, and in some ways, a distinctive feature of it. Non-discrimination is familiar to most of us as a key provision of international human rights law. However, the principle of non-discrimination is also well established, not only in constitutional law, but also in wider international law. Mikhail Rizvas, for example, notes that economic non-discrimination clauses have an extensive pedigree stretching back to ancient times in international law, even playing a crucial role in the development of the sovereign equality of states doctrine. Certainly, the content of non-discrimination provisions varies widely between different bodies of law. In essence, though, all are underpinned by the idea of correcting disadvantage that is in some way unjust. Justice, as Wojciech Sidursky argues, is thus inherent to the idea of non-discrimination. Moreover, drawing on Sandra Fredman's work, key questions that can help us understand the parameters of the non-discrimination principle across different legal contexts include at least two main features. Firstly, what makes a disadvantage unjust? Some legal sources treat as discriminatory any adverse distinction that has no, quotes, reasonable and objective basis in fact. Others, though, forbid specific grounds, such as race, to be used as the basis for differential treatment. These diverse responses suggest that the parameters of injustice vary between legal contexts, depending on the purpose of each body of law. Secondly, who or what is the comparator for assessing disadvantage? Again, this question cannot be easily answered in the abstract. Rather, the dictates of what is perceived as just in a particular legal context will point to the appropriate comparator against which potential discrimination is to be assessed. Overall, then, whilst non-discrimination is a well-established core legal principle, the way that its content is articulated appears to be highly contextual, reflecting the specific legal context and object and purpose of each body of constitutional or international law. One such legal context is international refugee law. The key purpose of the Refugee Convention, as the cornerstone treaty here, is to ensure protection for refugees whilst giving due regard to the sovereign concerns of contracting states. However, the non-discrimination principle crucially underpins the character of this protection in two main ways. Firstly, to be a refugee under the terms of Article 1A2 requires, inter alia, that the person is outside their country and lacks the national protection of their state. In the context of alienage, the injustice that may result from that lack of national protection is a key deficiency that the Convention addresses. Clearly, the drafters of the Refugee Convention were not prepared to correct that deficiency by creating a hard obligation to grant nationality to refugees. Even so, many of the intrinsic rights of refugees under the Convention correct some practical disadvantage of ineffective nationality. For example, by requiring the host state to give access to administrative assistance in Article 25 and identity documents in Article 27. The contingent rights granted under the Convention also level up, if you like, the legal situation of refugees, but do so by reference to some comparator group deemed appropriate by the drafters. Often that comparator group is aliens generally, and by virtue of Article 7.1, this is the fallback position. But equally often, parity is instead with most favoured nation status, or even more often, the host state's nationals. In short, these key provisions of the Convention are substantially concerned with alleviating the discrimination faced by refugees, specifically in their situation as aliens who lack national protection. They do so by requiring contracting states to engage in different forms of levelling up of this disadvantaged group. Of course, Convention refugees are not the only class of person to benefit from such levelling up in international law. Rather, a similar approach is applied also to a wider class of refugees and to stateless persons under the 1954 Stateless Persons Convention who are deemed to lack national protection. Secondly, this lack of national protection is linked to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion, as the Article 1A2 refugee definition specifies. In essence, then, and in contrast to other refugees and other unprotected aliens, the distinguishing defining feature of Convention refugees is their exposure to extreme discrimination in their country of origin. This is the second point at which the non-discrimination principle underpins the Convention regime. Certain strands of judicial and academic commentary already recognise the notion of discrimination as inherent in Article 1A2. Certainly, the 5 convention grounds are self-evidently the reasons on which the drafters decided the drawing of distinctions would be unjust in this context, as Raza Hussain and I have noted elsewhere. Moreover, as James Hathaway and Michelle Foster point out, judicial interpretations, both of the convention ground of particular social group and of the so-called nexus element, have drawn on parallel understandings of non-discrimination in constitutional law. However, by contrast, the being persecuted element of Article 1A2 is less often linked to ideas of discrimination and more often connected to a concept of serious harm, sometimes rooted in human rights standards. Indeed, as Rebecca Dowd observes, discrimination as a term is sometimes used in judicial practice as shorthand to dismiss lesser forms of mistreatment that are seen as not reaching the severity threshold for persecution. An underlying concern with protecting refugees from the implications of this extreme discrimination can be seen also in several rights clauses in the Convention, which either prevent refugees from being re-exposed to that extreme discrimination, as with the non-refoulement guarantee in Article 33, or remove any unjust legal disadvantage resulting from the refugee formally retaining a harmful nationality, as with the exemptions from reciprocity and exceptional measures in Articles 7, 2 and 8 of the Convention. In short, even if it's balanced against host state interests, a concern with avoiding discrimination in the form of unjust disadvantages resulting from the severing of the state-citizen link by persecution runs through these provisions of the Convention too. This brief analysis shows just how deeply the protection regime established by the 51 Convention is rooted in ideas of non-discrimination. But why does this matter? Briefly, I'd like to outline 5 reasons why I think this approach is useful. Firstly, non-discrimination provides a coherent rationale for the Convention as a whole, which is presently lacking. Specifically, the regime corrects certain unjust disadvantages that Convention refugees face due to their lack of national protection and due to persecution in their homeland. The rationale is thus one of helping those who are unjustly excluded to level up, rather than a rationale of conferring, if you like, a flat standard of human rights for all. Secondly, the non-discrimination rationale of the Convention firmly links the treaty to ideas of justice that should be at the root of all law, and it gives us an appropriate language with which to develop them in the refugee context. Thirdly, the concept of non-discrimination provides a bridge to other bodies of law which also express that principle. Mindful of their different purposes, we may still sometimes draw useful insight from them. For instance, current refugee law interpretation of the particular social group ground in Article 1A2 arguably draws on only a partial understanding of how non-discrimination law actually identifies protected groups. Conversely, although refugee law is marginal to non-discrimination scholarship, it has its own insights to offer that broader field of study. Fourthly, a non-discrimination-based approach sheds light on key elements in the Article 1A2 definition, not only the 5 grounds and the nexus element, but also the being persecuted element. Undoubtedly, that concept contains a threshold of severity, but equally, it plainly expresses the concept of discrimination, given the qualifying grounds stipulated thereafter. A focus on the many cumulative forms of discrimination that define the situation of marginalized persons should thus be the starting point for an inquiry into whether such discrimination is severe enough to tip over into persecution, rather than an approach that first seeks to identify some breach of fundamental human rights. Finally, the centrality of non-discrimination to the Refugee Convention requires us to reconsider the relationship of this refugee law regime to other forms of international protection, including pertinent points of both convergence and distinctiveness. In reality, then, it's clear that the situation of refugees is defined by the experience of many extreme forms of discrimination. For reasons of both justice and legal coherence, and after 70 years of applying the Convention, I join others in arguing that this is a point we should recognise in refugee law too. Many thanks.
Thank you, David, and thank you for keeping on time. That was fascinating, absolutely fascinating panel. Very much resonates with my recent look at the whole idea of resettlement in the interwar years and post. I think what this session has done is bring out how important the history of the Refugee Convention is to understanding what it was doing, and indeed what the Refugee Convention couldn't do. It really was an instrument for its time. But I think the objective of finding coherence is one that is never ending. Enough from me. We have some fascinating questions to our excellent panelists in the chat box. So can I suggest that we give, as we're doing quite well with time, as I see it, we can give each speaker 5 minutes to respond to the questions that are there in the chat. And if some people who are listening in have got questions, other questions, please continue to put them in the chat, and we'll try and get to them if time permits. So we'll take the speakers in the order in which they spoke. So first of all, Kathryn, then Kate, Elaine, and David, and in 5 minutes each. And if we have time, we'll go on to a second round of questions. Thank you. So I'll hand over first of all to Kathryn.
Thank you very much, Susan, and thank you everyone for your questions, and to the other panelists. It's been so interesting to listen to everyone. I'll start going through the questions and see how I do with time. So I'll go through them in the order they were written up. So Sarah's question around the disparate nature of the prohibition on forced displacement and how we can develop a more coherent approach to this. And I think it is disparate. And the way I've sort of viewed it, and when I've been doing my research on this, is that but what it does do is sort of form a net of protection, and that the different branches of international law that contain a prohibition on forced displacement, so humanitarian law, criminal law, and human rights law, are all operating in a specific circumstance and therefore have their role to play, but that they can talk to the other branches. And because of the specific circumstances in which humanitarian law operates, being armed conflict, and that criminal law obviously concerns individual, not state responsibility, but also that it has these kind of quite high severity thresholds, either as war crimes to be committed during armed conflict, but for crimes against humanity, they have to reach the severity threshold. So they have a specific focus and a specific circumstance in which to operate. And I think that's why developing our understanding of a right not to be displaced under human rights law is the avenue for which to have a more coherent approach, because this would give us a clearer understanding of what the scope is of a right not to be displaced, and therefore what the positive and negative obligations of the state are in relation to that, and therefore when it's been breached. And so I think we see each of these branches as having their specific role, but also as speaking to each other. And we do see that with criminal and humanitarian law and human rights law, understanding when there is a breach. So I think it's about seeing it as a kind of system that is talking to each other. And then moving on to David's point around whether it's helpful or not to view refugees within the broader lens of forcibly displaced persons. And I think the point I was hoping to make, and it's one that I've come to, is that actually the Refugee Convention and the protection provided to refugees is a very specific one. There are specific protection needs of refugees, and we shouldn't dilute this. But I do think there are interesting discussions, obviously, that have been had around the refugee definition and its application to people fleeing armed conflict and more generalised violence, but also the conversations that are ongoing around climate change and people fleeing climate change and their protection needs and where they fit within the framework. And I think they're important, but my feeling is we should be careful around over expanding who this protection is provided to. because for the purposes of responsibility of holding a state or an individual responsible for forced displacement, we're thinking about something else. We're thinking about that forced movement, and without linking it to the lack of protection and the fact that someone is fleeing persecution for a convention reason. And both of those things have an important role to play. And the point I was trying to make is we should keep them separate because they are separate. And this then moves me on to the point that Ruvi makes, I think, because the convention and the Refugee Convention is thinking about it's this future-based assessment. It's what Hélène was talking about. There is a temporal element that's looking forward. It's saying, is there a risk of persecution that the person that there is a well-founded fear of? Whereas thinking about responsibility is a backward-looking one. It's saying, has there been a breach of someone's right not to be displaced, of their human rights, has someone been forcibly transferred? And so this temporal element, I think, is what we need to keep in mind in what the Refugee Convention is doing and what responsibility for forced displacement is doing. And so Ruvi's point, I think I've got another couple of minutes, is around whether one can argue that developments of a right not to be displaced challenge this notion that the finding of someone to be a refugee is not necessarily condemnatory. And so I think that the point is this sort of forward-looking and backward-looking in the fact that when you find someone to be a refugee, it's about the future threat of persecution. But in so doing, you're making an assessment of the circumstances in the country of origin and the ability of the state to protect or their actual conduct. So, if we expand where the right right not to be displaced is, and we understand its scope and the obligations there, I am actually thinking about this at the moment. Could the finding of someone to be a refugee and therefore the assessment of the country of origin's conduct or lack of conduct, could that be evidence in a case someone brings to say that their right not to be displaced has been breached? And I don't have an answer to it, but I think it's a really interesting one that can will evolve as we continue to understand the scope of the right not to be displaced and this relationship between refugee law and human rights law. And the rights and obligations there. And I think this comes back to my first point around the systemic integration of these branches of law and the need for them to talk to each other. So I'll stop there and let the rest of the panelists have their moment, but thank you for the questions.
Thank you, Kathryn. Excellent responses. And I think is the point you're making has been made by others in different ways in this panel, namely that the Refugee Convention is a very basic instrument and there are many other bodies of law which intersect with it. Enough from me. I'll turn now to Kate and give Kate her 5 minutes. Thank you, Kate.
Okay, I'll also try and go through all the questions I was asked, and I'll just stop when 5 minutes comes up. So I think it was Ruvi asked the first question about this point he made about the assertion of sovereignty. So I argue that the way courts have interpreted Article 1D's second paragraph, an assertion of sovereignty. And Ruvi made the point that perhaps that's because in Article 1.2, the second 1D, the second paragraph, there is an ipso facto entitlements to the benefits of the Refugee Convention. So yes, if it is accepted that protection and assistance has ceased for a Palestinian refugee, they ipso facto automatically get the benefits of the Refugee Convention. They do not then have to prove that they are a refugee within the meaning of the definition in Article 1A2. So I guess the way I go, and I think too, the assertion of sovereignty point, this is something I didn't highlight, but I talk about in the book. Of course, we've got to remember, in particular in Europe, a lot of these decisions were being made in the context of displacement from the Syrian civil conflict. So many of those displaced were Palestinian refugees. And I think decision makers, even though they didn't refer to it in their judgments, were quite aware of the fact that if they had a very broad understanding of that second paragraph of Article 1D, it was, I don't want to use the word floodgates, but there we go, opening the floodgates, so to speak. So the way I sort of look at this, though, in the chapter is I really try and say, is Article 1D a containment mechanism? So you've got authors like Patricia Tuitt calling Article 1A2, the refugee definition, a containment mechanism. And she calls it a containment mechanism on the grounds that refugees, in 1951, when the convention was created, didn't have the non-refoulement was only a supposed benefit, because really the 1951 convention coincided with taking away unfettered free movement across borders. So I say, applying that to Article 1D, in a way, Palestinian refugees are even more greatly disenfranchised by the Refugee Convention, because they don't have this supposed, benefit of non-refoulement. They also don't have the benefit of unfettered free movement, and they have to gain protection. They have to stay where they are. They have to stay within an UNRWA region. But then, of course, you've got the second paragraph, and I think how you interpret the second paragraph, whether you interpret it broadly or narrowly, really is going to determine whether we can classify Article 1D as a containment mechanism or as liberation from containment. And those states and scholars who interpret Article 1D as historically bounded, I think they reach a balanced approach. They say, okay, most of the Palestinian refugees alive today, Article 1D doesn't apply to you. If you want to have refugee protection, though, you have to satisfy the definition in Article 1A2. So that's a fairly balanced approach. With those, most of the states who take that continuative approach, where that balance lies between containment and liberation really depends on how they're interpreting that second paragraph, which is why I really wanted to look at that. So yes, my view is that in the majority of cases, I would classify, Article 1D as very much a containment mechanism, because it's Article 1D, its second paragraph has been interpreted so narrowly and in really very few exceptional cases. David, you ask about the ultimate implications of the forced migration test. I mean, that's interesting. My view is that this is the only context in the 1951 Refugee Convention where decision makers have to grapple with this concept of forced migration, though it is in the African Refugee Convention. I'm not aware of any scholarship that's looked at how African decision makers have dealt with this idea of forced migration. I think that's a really interesting issue for further research, whether there's any parallels between Article 1D jurisprudence and African jurisprudence on this concept of forced migration. I think, though, that the ultimate implications, I think, are quite serious in the Article 1D context. I think the ultimate implications that it increases subjectivity in decision making. And so I draw a lot on Chimney and Tuitt's idea of objectivism, this idea that when decision makers are making these decisions, they import, their first world view on what is it to, leave against your will, for example. They import their first world assumptions onto a refugee who's come from a very, very different context. So I think the ultimate implications is increasing subjectivity. And Susan, your question about, I think that's my 5 minutes. My minutes is Bruce has written, and he wrote the decision in AD Palestine. I would love to hear from you, Bruce. I will send you a copy of the book when it's out, because I'd love to hear your thoughts. But congratulations. I actually think that the aspect of the judgment on protection and assistance is really wonderful, and it was the first judgment to explore this idea of protection and assistance for Palestinian refugees, and I think you did a stellar job. So thank you. Susan, I think you're muted.
The moment I'm muted. Yeah, sorry. Thank you, Kate. Excellent answers. And as you know, we will be talking soon. I'd like to turn now to Hélène for her responses. And we have some interesting questions in the chat. So over to you, Hélène. And perhaps it's fortunate there isn't a decision, fortunate or unfortunate, that there doesn't appear to be a decision maker in your case in the...
Thank you, Susan. So I've got a question from David, which basically asks about the context of disaster and climate change and whether it's any different essentially to armed conflicts. Well, it's interesting. It's a great question, because we've actually looked into that. And as it happens, Matt Scott, I don't know if Scott is in the audience or not, but he wrote a book precisely on that issue, where he does tackle these elements of certainty of events and considerations of time. And he relies on some of the work we've published previously on issues of imminence. And what we seem to be in agreement with is it doesn't matter so much the context. it can be disaster, it can be climate change, it can be armed conflict. Ultimately, the considerations of time are similar and raise similar, if you want, questions that needs answering, and they end up revealing the same kind of processes of thinking and reasoning by the courts or tribunals. So I don't think there is much difference in these contexts. They raise very similar issues of temporality or time, and they've been dealt with. Well, obviously there's far less decisions on climate change than there is on armed conflict, but I don't see any difference between the two in terms of context and the issues they raise. Moving on to Cecilia Ballier. Yes, about data. The impact of AI, drone surveillance, and other technological innovation. Yes, I mean, they can be useful. I mean, I think they would be useful in terms of predictability and being able to predict the future. That would be tremendously helpful. As to add extra layers of data on the immediate, as to, you know, the events as they are unrolling now, I suppose then they fall in the same category as country of origin information, whereby it's all about the now, it's all about the past, and not enough about the future. So if indeed this technology can help us predict, so be able to really do this foreseeable assessment of the future beyond the now and the current, that would be tremendously helpful. Otherwise, I'm not sure they'll add much to what we've got already. And then there was a question by Bruce. What is my view on the relationship between time and certainty in the context of RSD? Well, that's the key issue, isn't it? And the issue of certainty relates to events, basically. It is very much about events. It is about evidence, and unfortunately, it doesn't relate necessarily as it should to considerations of time, which should invite a decision maker to look beyond the now and the certainty of events as they are presented now. But the reasonably foreseeable future test does require to look beyond this certainty of events and to look into prediction. And so I think that was really the key message of our findings in all the decisions we've looked at on armed conflict, was that sometimes there is this conflation between the two, between this notion of foreseeability, i.e. going beyond the immediate, the imminent, the now, the current, and to predict, to project oneself into the future. And what we found was that decision makers found it particularly difficult when there is, this volatility between peace and conflict, which is intrinsic in armed conflict, particularly situations of protracted armed conflict. So it was really about highlighting where there might be need for perhaps more reflection on how to approach these situations between peace and war. And then there was a question from Hugo, and it was
Hélène,
about, yeah.
Sorry to interrupt. There is one other. No. There is one other question in the chat. If you've got time to look at that also.
Oh, quantitative data have intrinsic limitation. What kind of qualitative?
Yes.
Could be used to make predictions? Well, that's tricky. I mean, personally, I think the judgment of decision makers should be should be sufficient. The standard of proof is reasonably low in refugee cases. So I think with the low standard of proof in refugee cases, coupled with data and reasonable judgment, one should be able to make reasonable prediction of the future beyond the now, the imminent, the immediate, which is all that is required, really. And that ties me back to, this Sivakumaran case of 1991, which we all know so well because of the standard of proof it's set in refugee law. But it is so interesting about in what it says about time as well, is this notion that fear must be current. We all understand that, but the risk doesn't need to be. So yes, an applicant must fear currently, but risk can be in the future. It can be now or in the future. And the court was very clear on that, and that the future is not the immediate future. It goes beyond that. And so that, in my view, still remains perhaps the most clear expression of what the well-founded fear of being persecuted means in terms of time. Thank you, Susan.
Have you finished, Hélène? Have you finished?
I think so. I'm not sure if the last question was for me or not. Not too sure, Maria.
I think we should let David have his turn now, and then if we've got time, we can have one quick sweep at the end, if that's okay with you. Okay, thank you, Hélène. Thank you.
Okay,
David,
well,
I was asking you to respond. I'm sure you understood what I was saying.
Good. Well, thanks, Susan. Well, look, thanks everybody for the questions and comments in the chat box. There are a number of really important issues raised there, and I'm really going to reflect on them carefully as this is written up for publication. Taking them in the order that they're given, Jean-François Durier, you make a comment about, well, talking about persecution element in particular, isn't the key question then moving to the threshold? At what point or in what circumstances does discrimination become extreme enough to, quotes, amount to persecution? I think that is a question. I don't know if it's the key question. But my response to that is, yes, certainly there is this severity element there. But I think that the chase for greater certainty around what severity means has quite often led us on strange paths. And at the end of the day, trying to work out what is severe enough to count as persecution is often quite a contextual assessment. And that's why I think a discrimination-based approach helps. I'm aware, of course, that there are many participants on the call who subscribe to a view that human rights law can be brought into play to tell us what the threshold of persecution is. And I've published previously on that. I don't find it a particularly persuasive argument. It tends to displace the problem, I feel, rather than solve it. And to the extent it solves it, it narrows or raises the threshold to persecution extremely high. You could draw lessons, I think, from similar difficulties that have been faced in the sphere of international criminal law, where the concept of persecution equally exists. And there was an attempt to define it as breaches of fundamental human rights. But in essence, the courts ended up saying, well, breaches of fundamental human rights, but lots of other things as well. Yeah, threats and adverse impacts of all sorts of kinds that may not be human rights violations in and of themselves. So I think in both fields of law, one sees a difficulty between trying to give a very prescriptive approach to what severity means. Certainly there is a severity element there. I'm not sure we found an answer to it, and I'm not sure that discrimination law will give us an immediate answer to it either. I think it's simply one of those areas that is, to some extent, an imponderable of refugee law. So I hope that's not too negative a response to that. I've then got a question from Hugo Story, which is asking about, well, okay, you know, if discrimination is a foundational norm, how relevant is it that the Convention's preamble is packaged as part of a human rights instrument, the Universal Declaration? And I think in response to that, the fairly clear answer is yes, of course, the Convention's preamble does, amongst other things, refer to the Universal Declaration on Human Rights. But I think the way that one engages with that is to say that you know, the drafters are very clear there that you level refugees up to an extent where they can start exercising human rights. And really, I think the focus there is very much on you know, the totality of the refugee situation. I don't think it's just talking about human rights in the country of origin. I think, if anything, it's probably more focused on the exercise of human rights in the context of alienage, i.e. outside the country. I don't think that the Convention is, if you like, a traditional human rights instrument, although I can understand why some people might want to make those connections. And, you know, there are points of similarity, but I think the points of difference are quite substantial as well. Hugo Story also asks, isn't the reason why non-discrimination law has become so effective that it's been particularized within international human rights law treaties? Well, I think, you know, it is an area of law, and I should say I'm not an expert on non-discrimination law by any stretch of the imagination, but reading into the materials, it's very clear that, you know, there is a distinction, I think, between international human rights law and the expression of non-discrimination principles there, and constitutional expressions of that principle. For instance, there isn't a clear articulation in international human rights treaty law that sexuality is a protected ground, whereas that has been clearly articulated in constitutional law. So there are a range of different approaches there, and certainly international human rights law has you know, played into the debate, but I don't think that it's the only part of the story. And really what I'd like to try and do is get us away from thinking that, non-discrimination is only non-discrimination in international human rights law. It has a much richer content than that. So one final question from Dr. Story, which is, if you're right and discrimination is a necessary element of persecution, then what about serious harm that's not discriminatory? Well, it's not persecution as far as I can see. Okay, moving on to questions from Ruvi Ziegler. You've asked about an interpretive question relates to the transposition or not of direct discrimination, never justified, as opposed to indirect discrimination, which can sometimes be justified. This is a distinction which is common in human rights jurisprudence. Does it have a role in refugee jurisprudence? Yeah, I mean, that distinction is there in some bodies of discrimination law. In other bodies of discrimination law, that distinction seems to be more broken down, in the sense that direct discrimination might in some very rare cases be justified, and there are some forms of indirect discrimination that might never be justified. So, you know, there is a distinction that's often used, but it's more flexible, I think, than it sometimes seems, for example, in the UK Equality Act, which you've referred to. My sense is that those kind of discrimination-based concepts do help us to think through about predicament-based approaches to how we understand the concept of persecution. So yeah, there is a role for those sorts of things, but I think that, you know, we draw on them with care rather than directly applying them into the refugee context. The other thing that I'd say is that, you know, I agree with the direction of travel of the question, and I think that treating the persecution nexus and reasons elements as fundamentally discrimination-based do shed light on quite a number of important areas that we've struggled with in refugee law. So the distinction between prosecution and persecution, I think, is not a debate about what's protected under human rights law. I think it's fundamentally a debate about what amounts to discrimination. How do you identify discrimination? Similarly, if we talk about, you know, people coming from contexts where you know, there's extreme poverty, you know, how do you distinguish those who are persecuted from those who are not? Again, I think those are questions fundamentally about discrimination, and a discrimination-based approach helps us in a way that some other approaches might not do, to differentiate those who fall within the scope of the convention from those who perhaps don't. The last question, in fact, there's a couple of comments around this. The question's from Sarah Singer, and she says, well, you know, if discrimination is the foundation of the refugee definition, Does this make it more tricky to extend to groups fleeing widespread non-discriminatory violence? Is it desirable to retain this tighter approach? I mean, I think if, again, persecution is fundamentally about extreme discrimination. Okay, if one takes that view, then where we're talking about non-discriminatory violence, then we're not talking about refugees. Of course, there may be other forms of international protection that are available to those persons, but convention refugees, the discrimination element is absolutely key there. I agree, however, with what Maria O'Sullivan has said, which is that I personally think there's no such thing as generalized violence. Well, there may or may not be, but there is, she says, often a discriminatory element within these contexts of conflict, or what are sometimes dismissed as generalized violence, some form of targeting, i.e. targeting of certain areas in Iraq where particular groups of religions congregate, etc. So I agree with that. And I think actually in the UNHCR guidelines now, that kind of predicament-based approach, looking very carefully at the way in which particular sectors are exposed to differential forms of harm, is useful, and that is really based on a discrimination approach. So I think it finds some reflection in the guidance that UNHCR has offered there. I'm going to leave it there, but thank you very, very much for those questions. I'm not sure I've done a great job of answering them, but there's certainly points I'd like to think about further.
Thank you, David. Excellent answers that actually raise a lot more questions. We've got, as I see, 4 minutes, so perhaps we'll give everybody a chance, 1 minute each, starting again from the beginning, starting again with Kathryn, and give you a chance just to elaborate on a point or to respond to a question that you didn't get around to answering. So first of all, Kathryn, 1 minute, please.
Okay, I'll be very, very quick. There was one final question I hadn't got to, but I think it was more of a comment from you, Susan, around looking at the focus on the freedom of movement in the drafting of the Universal Declaration of Human Rights. And I have looked at the drafting of the Universal Declaration as well as the conventions that came later around the right to free movement and also the right to seek asylum, and the fact that these were responding to an acknowledgement and trying to prevent the forcible movement that had been seen. But I think the thing that I think is really interesting about this time is that was happening on the one hand, and on the other hand, there was still this perception that states could group together and say, we're going to move these groups of people because that will create these homogenous nation states, and that made it legitimate. And I think that's just a really interesting context in which, at the same time, there was conversations around who is a refugee and what is it that makes a person a refugee, as opposed to these people who we can just lift up and move over here, and many of them will die in the process of these forcible transfers. So I think there's this really interesting conflict there, and what you saw later on, is these same politicians that agreed the Potsdam Agreement then saying, oh my goodness, we've done something awful and we violated these rights, and it took it almost to happen for that realization to occur. And I think that's what was feeding into the Refugee Convention and its drafting. So that was my final point, but thank you everyone for the discussion and questions.
Thank you, absolutely fascinating. I think the history is so important, but that's my particular bias. Kate, did you want to add something?
Oh, I've just got a few questions about the 2021 decision, Court of Justice of the European decision of XT, which basically it's almost like trying to insert an internal relocation test into Article 1D. So I actually have published on this, not in relation to the 2021 decision, but in relation to a Austrian decision of 2014, which essentially was, doing the same thing. My view is that it is really inconsistent with Article 1D's text. It says, when such protection and assistance has ceased for any reasons, these persons shall ipso facto be entitled. So it's, it's on the cessation of that protection and assistance that ipso facto refugee, the benefits of the Refugee Convention should be granted. But also, and I think this is more problematic, all the scholars who look, advocate for continuative interpretation, it's on the ground of continuity of protection for Palestinian refugees. And once you insert an internal relocation test, you've got this situation where protection is almost suspended for a period of time. So I think it's really antithetical to the sort of principled interpretation of Article 1D from a continuative perspective. And the third point I'll make, that case unfortunately isn't in the book because I stopped the book at the end of 2020 because I had to stop it somewhere, but it plays into this idea, completely plays into this idea of global north states pushing back protection to the responsibility of states, lower income countries, and completely underfunded and overstretched international institutions.
Thank you, Kate, for that brief and helpful response. Hélène and David, did you want to say anything else very briefly? Because we are actually on time, but we'll be over time.
Thank you, Susan. I'll just literally be very, very brief, but it's an interesting question from Maria O'Sullivan. It'd be interesting to see how decision makers will assess troop withdrawals from Afghanistan in relation to future risk. And as it happens, there has been a lot of, decisions taken on, obviously not about the now, but in the past, relating to troop withdrawals from Afghanistan and elsewhere. And it's interesting because we really scrutinize carefully there how the time frame that decision makers used as to whether they would use as a look at the situation in 1 week time or in 3 months ahead, and how they would predict the future. And I mean, the conclusion we have is that there is no consistency between decisions, and so which is what we highlighted in our paper is that more consistency would be welcome. But thanks for that, Maria, and for everyone for your questions. Much appreciated. Thank you.
David, did you want to have the last word?
Well, I hope you'll have the last word, but just to say that I think it really is important to think about the convention and its relation to discrimination. Of course, that doesn't mean that human rights law isn't important for all sorts of reasons, and you'll see on other panels where that discussion takes place. But for the Refugee Convention, certainly we should be thinking more carefully about the way in which discrimination plays out there. And thanks very much, Maria and Ruby. I think conscription cases are another area where discrimination is at the heart of that. So ending on a Refugee Convention note. Thank you.
Thank you, David. And thank you to all the panelists, and thank you to all the people listening in for your engaging questions. I think it's been a really interesting and engaging panel. So many thanks indeed. And thank you for giving me the opportunity to chair and to remotely share with some of my very dear old friends around the world. So wishing everybody well, and goodbye for now.